Okay. Woo! Oh, please. Please, everyone, calm down. Come on. I know, I'm back. My name is Levi Graham Weinstein, and this is an interesting case. So, this is Arnaldo Vega. Arnaldo is the employee, and the employer is Big Dog Express of South Florida. Fine. Big Dog was my nickname in high school. And the attorneys here are Monica Amore v. Thomas Montgomery. Ding ding! I need that on my soundboard. So the claims, and by the way, I chose this case because it looked kind of dramatic, you know. It's currently 5/11, December 18th, 2023. It's been a long day. Didn't get a lot of sleep last night, and did a lot of work today. So I wanted to read something, you know, dramatic, and I found this one. So all right, Arnaldo Vega. I actually had a best friend named Arnaldo in elementary school. That's not a joke. Or maybe it was Ernesto. Okay, we're moving on. So the claims. What was the claimant looking for? The claimant was looking for compensability of the accident. So just like saying, hey, this, like, please provide medical benefits, and authorization of a doctor to treat extensive burns. Ouch. And transportation and an interpreter. So the claimant is looking for compensability, a doctor, transportation to the doctor, and an interpreter while at the doctor. The employer is saying nah. The employer is putting forth no affirmative defenses. The employer contends the claimant is unable to meet his burden to establish an accident arising out of the course and scope of his employment. In English, what the employer is saying, this was not a workers' comp accident. Therefore, we're not going to pay. So, findings of fact and conclusions of law. Let's see what happened here. Okay. All right. The claimant is a Cuban native who emigrated to the United States in May of 2019. On July 14th, 2021, he was involved in an industrial accident while working for Big Dog Express of South Florida, aka Big Dog, as an operator of equipment. Specifically, the claimant was operating a front-end loader when it began overheating. He testified that after he contacted his supervisor, Alfredo, he went to check the engine and hot water burst all over him. Ouch! He fell unconscious and testified he remained unconscious for 53 days? Sheesh. The medical records reflect the claimant was admitted to Jackson Memorial Hospital Trauma Burn Center, Jackson, on July 14th, 2021. He remained hospitalized at Jackson until his discharge on September 10th, 2021. At Jackson, the claimant was primarily treated for burns involving 30 to 39% of his body surface with 0 to 9% third-degree burns. Okay, I just want to say, first and foremost, this sounds like a work accident. Like, he was operating a front loader and water got all over him. Like, that just sounds terrible. The burns were principally to... The claimant was also diagnosed with acute respiratory failure with hypoxia and pneumonia due Klebsiella pneumonia. The burns were principally to the claimant's arms, torso, abdomen, groin, ouch, and thighs. He underwent debridement procedures on July 21st, 2021 and July 30th, 2021. And open tracheostomy on August 6, 2021. He received extensive occupational therapy during his hospitalization. I don't know if you've watched Bad Surgeon on Netflix, but seeing that word, a tracheostomy, oh my God. Watch Bad Surgeon on Netflix. It is super messed up. All right. Following his discharge from Jackson, the claimant began treating with Dr. Vanny Sebastian, orthopedic, as early as February 18th, 2022. The claimant presented to Dr. Sebastian with a history of the industrial accident and complaints of bilateral elbow pain. On March 17th, 2022, is that St. Patrick's Day? Woo! He underwent right elbow open debridement, capsular release osteotomy. Funny, osteotomy. That was my nickname in high school. Heterotopic ossification, excision, like the DJ. Okay, sorry. Ulnar nerve release and manipulation under anesthesia. The claimant received physical therapy before undergoing similar surgical intervention to the left elbow on May 19th, 2022. Again, he received post-surgery therapy. On October 9th, the claimant was seen for an IME with Dr. Edward Lazarin, an orthopedic surgeon. Ooh, an IME. That's when you know things are spicing up. Dr. Lazarin reviewed the medical records from Jackson, Dr. Sebastian, and JFK Medical Center. He took a history from the claimant that was consistent with the testimony and documentary evidence regarding the industrial accident. He performed a physical examination and assessed the claimant with severe left elbow pain with marked epicondylar tendinitis and severe left grip strength loss, weakness, numbness, and tingling in the left hand. Dr. Lazarin recommended an MRI of the left elbow, cortisone injections, physical therapy, and possible surgery, as well as neurologic consultation, medication, and possible bracing. God, this guy got messed up. I feel terrible. There is no dispute the claimant carries the initial burden to establish an accidental injury arising out of the course and scope of employment, proved by objective relevant medical findings establishing that the accident is the major contributing cause of his injuries. I find the claimant has met his burden to establish compensability. I accept the claimant's testimony that he was in the course of performing work for the employer when he was injured on July 14th, 2021. Further, I accept the unchallenged, singular, admissible medical opinion from Dr. Lazarin, the claimant's IME. Please hold. Please hold. We're on hold right now. Further, I accept the unchallenged singular admissible medical opinion from Dr. Lazarin, the claimant's IME. Dr. Lazarin took a history, reviewed the relevant medical records, performed a physical examination, and opined the industrial accident was the major contributing cause of the injuries sustained. I find Dr. Lazarin's testimony was well-founded, logical, and self-evident. Ooh, okay. Again, the claimant's injuries and Dr. Lazarin's opinions were not disputed by the employer. Rather, the employer primarily defended the matter upon the contention that the accident was an intentional act by the claimant. Okay, I am an employer's attorney, and I don't know. I mean, I get, maybe there's facts here that I'm unaware of to think that this would be an intentional action. But that would be like, I find it hard to believe that this was an intentional action. He was in a coma for 53 days. But the employer is saying that this was an intentional act by the claimant. Okay, hold on one second. Okay, and we're back, just like nothing ever happened. So again, the employer thinks that the employer thinks that the claimant did this on purpose somehow. It should be noted that the employer did not assert an affirmative defense such as Section 440.093 Florida statutes in the pretrial stipulation or any subsequent pleadings. The employer did not file a trial memo. Accordingly, who is representing the... Okay, what's going on here? Accordingly, the employer's argument was predicated upon a contention the claimant could not meet his burden to establish the accident was accidental, as required. Okay, there has to be more to this story. If a Florida barred attorney is not submitting a trial memorandum and also saying that burning yourself with super hot water and going into a coma for 53 days is on purpose, what's really going on here, you know? So, Section 440.021 Florida statutes defines accident as an unexpected or unusual event or result that happens suddenly. The employer theorized that the claimant was too experienced a mechanic to have acted so recklessly as to open the radiator cap while it was overheating, or that the claimant intentionally pulled the hose. The employer posited the claimant was strategically trying to injure himself. Wait, do I have like dramatic music? Hold on. Oh, come on. I must have some dramatic music. This requires some dramatic music. Oh, wait. I think this is going to be good. Hold on. Wait. If what I just found. Yeah. Okay. The employer theorized that the claimant was too. Oh, wait. The employer posited the claimant was strategically trying to seriously injure himself so as to obtain a caretaker visa for his wife who is still in Cuba. Oh, wait, that wasn't loud enough. Hold on. There was no evidence presented to substantiate the employer's theory. Spooky. Okay, let's get back to the fun music. Hold on. Okay. The employer posited the claimant was strategically trying to injure himself so as to obtain a caretaker visa for his wife who's still in Cuba. There was no evidence presented to substantiate the employer's theory. Yeah, probably because there was no trial memo. Rather, the evidence reflected the claimant had advised the employer that the machine was overheating prior to the date of accident, that there was some effort to fix the problem, and that it continued to malfunction. There was no evidence to support the claimant manufactured the incident. There was no evidence that a visa was sought thereafter. I find the incident was accidental. Great job, Your Honor. And that the claimant did not injure himself intentionally. During the hearing, the owner of Big Dog, Emilio Perez, testified that he considered the claimant to be an independent contractor. Oh, here we go. So in workers' compensation law, you have to be an employee to be eligible for workers' comp benefits. Independent contractors, as a general rule, are not, but there's a billion exceptions that allow independent contractors to receive workers' comp benefits. I'm sure I'll go over that in a video at some point. But nonetheless, during the hearing, the owner of Big Dog, I'm Big Dog. No one's owning me. Okay, sorry. During the hearing, it's been a long day. During the hearing, the owner of Big Dog, Emilio Perez, testified that he considered the claimant to be an independent contractor. On July 16th, 2023, the parties completed a pretrial stipulation in which the employer confirmed there was an employer-employee relationship on date of accident. See box 5. Are you kidding me? On August 1st, 2023, the parties attended a bifurcated final hearing. At that time, the employer again confirmed the stipulation of employer-employee relationship. The bifurcated final compensation order entered August 31st, 2023, documented the stipulations between the parties as including there was an employer-employee relationship on the date of an accident. So let me stop right there and explain something. At final hearing, the employer is saying, oh, he wasn't my employee. But before that, at a hearing and written down in a pre-trial stipulation, the employer said that he was an employee. Make up your mind. So, At the commencement of the subject final hearing, the undersigned reviewed the pretrial stipulation and confirmed the stipulations, including employer-employee relationship. It was not until the testimony of Mr. Perez that the issue or dispute of employment was asserted. We're getting there. Pretrial stipulations prescribing issues on which a case is to be tried are binding upon the parties and the court, and should be strictly enforced. I find the employer stipulated in the pretrial stipulation at the bifurcated final hearing and at the incident final hearing that there was an employer-employee relationship. I conclude the employer is bound by that stipulation. Again, the purpose of the pretrial stipulation is to frame the issues of dispute for the trial. It would be incredibly prejudicial for the employer to enter such a stipulation and then at trial assert for the first time that there was no stipulation. As the claimant was not alerted to the notion that he would have to present evidence to establish an employment relationship, the issue of employment was subject to stipulation and is enforced. Further, there was no dispute the claimant was performing work for the employer at the time of the accident. I find the claimant has established... Great job, Your Honor. I find the claimant has established that there was an employer-employee relationship, that he suffered an accidental injury arising out of the course and scope of employment, which resulted in the claimed injuries. In that, the claimant established compensability of the injury. Wait, hold on. In that, the claimant established compensability of the injury. The employer has a duty to furnish treatment with the medical provider. Nice. Inherent in the duty to provide medical care, the employer is legally obligated. Hold on, we gotta get some music going again. No, that's the theme. I don't think I played that in the beginning. Whatever. I find the claimant has established that there was an... Okay, I already read that. Finally, it is well settled that an employer must furnish transportation to authorize medical appointments or pay the reasonable cost thereof. So he's gonna be provided with transportation and interpretation. Okay. Your Honor, Judge Hedler, I think that you made the right decision here. I don't know what's going on with Big Dog. I'm the real Big Dog. Remember that, Big Dog employers. And you know what? To the claimant, I wish you well. I hope that, Mr. Vega, you're my second favorite Vega. First favorite Vega is Vincent Vega. If you know where that's from, you're cool. For the listeners, I love you. And thank you so much for enjoying this episode of Levi the Lawyer with me. For the listeners, adios. For the listeners, make sure you're following me at Lawyer Levi. My Instagram handle is Lawyer Levi. Make sure you're following me. And if you have any legal questions, shoot me a DM at Lawyer Levi. All right, friends, that's it. I love you. Peace. I'm gonna start incorporating like my own music into this. I'm excited about that.